From the minute we're old enough to watch TV and movies, we develop a mental image of how the American judicial system works. On one side is the prosecutor, on the other is a defendant represented by a defense attorney. In the middle is a judge, a neutral arbiter. Judges are expected to be impartial and make decisions based solely on the evidence and the law. And the courts are expected to be independent from any outside influence. This image is reinforced by what we are taught in school, where we are introduced to terms like judicial independence, and we're taught about the separation of powers. Right? Wrong, if you're talking about the federal immigration courts. Hello, I'm Judge Ashley Tabador, the president of the National Association of Immigration Judges, the organization representing our nation's more than 400 immigration judges. I'm also a judge on the bench in Los Angeles, California. I'm here to tell you firsthand that the immigration courts are nothing like what you had ever imagined. Our immigration courts and judges are not in the judicial branch of the government. Our immigration courts and judges are not independent. They are set up in a federal agency, the U.S. Department of Justice. As strange as it may seem, the U.S. Attorney General, the nation's chief federal prosecutor, heads the immigration courts and supervises the judges. The Attorney General can discipline or fire them. As a result, the immigration court is subject to political influences, and sometimes the executive branch uses the immigration court to deliver political messages rather than simply following the law and courtroom procedure. For example, the Attorney General can insert himself into specific cases whenever he chooses, switching roles from a chief prosecutor to the judge deciding the case. Cases are then stripped from the judge's docket, and the Attorney General then issues a decision, often rewriting the law to suit the whims of the political party in power. This is not blind justice. Additionally, the Department of Justice has imposed new rules requiring immigration judges to complete 700 cases a year to speed up the hearing process. If a judge doesn't complete the required number of cases in a year, he or she can be fired. This assembly line justice pits the judge's job security against his or her duty to be an independent decision maker. This is not how our judicial system should work. This is a violation of due process required under our Constitution. It shouldn't be this way. We can fix this. Courts and judges should follow solely the law and evidence of the case, rather than lurch from one set of policies and procedures to another as administrations change. Courts should be free from undue influence. It's time to create an independent immigration court. Court reform is tough, but creating an immigration court system free from outside influence is a reform that people of all political persuasions should be able to agree on. Creating an independent immigration court is not without precedent. Such a court could be modeled after similar federal courts, such as the bankruptcy court and the tax court, both of which Congress moved from the executive branch to avoid conflicts of interest. Right now, the immigration court system is dealing with a crushing backlog. Almost 900,000 cases are pending before the nation's roughly 400 immigration judges. Now is the time to reform the immigration court, remove it from the Justice Department, and protect it from undue political pressure. Now is the time for an independent immigration court.